10261, Haddad versus Wal-Mart stores.
Good morning, Mr. Mantel.
Good morning.
Yeah.
I represent Cynthia Haddad. I have with me Rick Fredette and David Belfort. And I'd like to draw this court's attention to the case of Rowlett versus Anheuser-Busch, which represented the state of the law when the legislature amended Chapter 151B in 1989 to permit the award of punitive damages. Now, when the legislature did that, it did not impose any standards, any limits. It did so intending that the restatement of tort standards for punitive damages be controlling. And in 1987, just before then, the First Circuit decided a case under 42 U.S.C. Section 1983. It was a race discrimination and employment case which turned upon inferential evidence of discrimination and which used the McDonnell-Douglas standard.
You say the legislature, and maybe you have this in your brief and I missed it, you say the legislature intended to use the restatement of torts as the standard. Is that based on legislative history, or from where do you draw that?
Well, I draw that from this court's practice of using the common law to interpret terms of Chapter 151B, which are not defined.
I appreciate the fact that DART certainly does that, but I thought from what you said that there was the legislature had made some connection, but that's not what you mean. Exactly.
It's not in the legislative history, but when the legislature provides for the award of punitive damages, one assumes that it's going to use the standards that are already in effect. And the court held that discrimination proved based on the McDonnell-Douglas standard constitutes intentional discrimination. And in turn, that intentional discrimination is sufficient to award punitive damages.
So would that mean that except in the cases that you talk about where there may be some question whether the person is aware that it was intentional discrimination, that in every case where a plaintiff succeeds in proving the necessary discrimination, he or she would be entitled to, if the jury saw fit, with nothing more at all, to punitive damages?
No, Your Honor. There are cases where there is legal ambiguity, where the law is not clear.
Well, I'm saying, right, and that's what I was inartfully talking about. But so put those to one side.
That's correct.
In a case, gender discrimination is not legally ambiguous.
That's correct.
I think we can assume. So in any gender discrimination case or race discrimination case, you would say a plaintiff who succeeds in showing, in proving liability is ipso facto or by definition also entitled to get, if the jury sees fit, punitive damages with nothing more.
A jury has the discretion to award punitive damages if it finds intentional discrimination and if it finds that the employer has an evil motive. But the evil motive could be, I take it your view is evil motive can equate with intentional discrimination. It doesn't need to be anything else. It certainly can.
What about
Well, do you mean evil motive, specific intent to violate a known legal responsibility? In other words, I intend to violate this law by doing this.
No, Your Honor. You could have evil motive simply through discrimination.
But why is that? I mean, I thought punitive damages were to discourage intentional conduct. I mean, isn't it, right?
No, Your Honor.
No?
On pages 29 through 30 of Ms. Haddad's reply brief, we have a number of tort cases, and the standard for tort cases is not, say, for example, libel. The standard is not, did the defendant know about New York Times versus Sullivan when it defamed the plaintiff? They never look to knowledge of the common law. They look to malice and intent to injure.
So you're saying that evil motive is a requirement of punitive damages, but evil motive can be found by a verdict of discrimination?
Well, there's two ways to prove punitive damages, evil motive or reckless disregard for rights. And we have both here, but focusing on evil motive, can have...
Don't you actually say three? Also,
There's
the
three.
violation of the law? Known
Yeah,
violation of the law?
knowing violation of the law, evil motive, and reckless disregard of rights. And yes, if you're focusing on evil motive, you don't have to prove specific knowledge of the law. Of course, everyone knows that gender discrimination is illegal.
But isn't there a requirement of heightened culpability, something more than just the prima facie case?
There's two answers to that. No.
Well,
The first
that-
answer is the Smith versus...
But isn't that what we said in Dart? I mean, Dart was a 151B.
DART did not talk about a heightened standard of liability over and above proof of evil motive or reckless disregard for rights. What DART was concerned about was an innocent employer, an accidental employer. DART was very clear that there was lots of ambiguity as to whether DART was even in the protected class. He was not injured. He was not disabled at all. He was pursuing theories that 2 years back he had a workers' comp claim, and the court found that he couldn't even fall into the protected category based on that. So in that and in other cases, looking at these cases that find no punitive damages, they all seem to bunch around the handicap discrimination context. The Smith versus Bell Atlantic, DART. A few weeks ago in the First Circuit, there was a case called Tobin. These are all handicap discrimination cases where it's unclear to everyone exactly what the obligations are. So this DART was an attempt to...
But to pursue Justice Fina's question, I know you're giving them names, but in essence, tell me why I am would be wrong in summarizing your argument and saying if the jury conclude that there was gender discrimination, there is no limit on the amount of punitive damages that they can award.
This case is not about that. This case awarded a 1-for-1 ratio with actual damages and punitive damages.
But I have to write an opinion, or somebody up here has to write an opinion that gives guidance to people. So if you say 1-for-1 is okay, and I'm not asking you to say it's got to be 5-for-1, what you are suggesting is that there is some limiting construct.
There absolutely is a limiting construct.
And then what is that limitation when you have a violation of our discrimination laws as opposed to, BMW or something like that?
Well, what we have here is not only intentional discrimination, it's malice and an intent to harm. And if you want
Do we have to have specific findings by the jury on that?
No, but I think that's all bundled into the notion of evil motive.
And so what does the judge have to ask the jury?
The judge has to ask the jury, as the conscience of the community, whether the employer had an evil motive. And that's sufficient. If the judge wants to embellish beyond that, I think
Are you
that's
saying
fine.
essentially that once there's a finding that she was fired because she was a woman, isn't that's sufficiently outrageous today to fire a woman in a situation in which a man wouldn't be fired? Is that essentially what you're saying? That
It is, but we have even more than that in this case. We have
Yeah.
a pharmacist who's been accused of stealing drugs, even though they admit they never suspected her of stealing drugs.
Well, I couldn't tell exactly, but isn't the reason, at least that Wal-Mart gives, would be that she left the post unattended
Which
to get
reason?
a soda?
That was one of the reasons, and that was the reason they gave after they accused her of misappropriating drugs.
I've got to say, I'm having considerable difficulty understanding your answers to the questions that several justices have been asking you. If a plaintiff puts forth a prima facie case of gender discrimination and the jury agrees, does the plaintiff have to show any more than that in order to get punitive damages?
The plaintiff must show prima facie case. The plaintiff must show pretext beyond that. The plaintiff must beyond that show intentional discrimination as opposed to unconscious discrimination, and the plaintiff must also show evil motive or knowing violation of a known rule. So there is actually lots of, and the jury was properly instructed. The jury was told they had to find intentional discrimination, evil motive, conduct worthy of condemnation, and fix an amount of damages that was necessary to deter discrimination in the future. That's a lot of levels, and that's a lot of limitations.
So, you have no trouble with the instructions. Your point is the judge didn't follow his instructions in taking away the award.
That's correct.
Well, what the judge, in fact, did something quite different. What the judge said is, and it was almost, this is on a JNOV, right?
That's correct.
And what the judge says is the plaintiff presented no evidence that Wal-Mart knowingly or intentionally violated 151B.
That's correct.
Now, we often have jury verdicts which are correctly instructed, right? So you go through all the instructions, you go through all the evidence, the jury awards, never mind on punitive, just on underlying came. And the judge comes back and says, I was there, I heard the evidence, and there was, in fact, no evidence that Wal-Mart knowingly or intentionally violated.
But that's a standard that may be for age, but not for gender. That's your point.
That's my point, yes. And the judge also talked about this being a close case when that's not the standard at all. Once the jury finds intentionality and evil motive, that's sufficient. And that's where Rowlett comes in, because Rowlett says...
Can I go back, what you, again, maybe Justice Spina and I mean, you just answered Justice Botsford by saying that's not applicable to a gender case.
No. Knowing violation of a known law can be applicable to a gender case, but actually there's 3 legs of the standard for gender. Knowing violation of a known law, or evil motive, or reckless disregard. When the judge focused on the knowing violation of a known law, the judge ignored the other legs and ignored his own instructions. He doesn't focus on the plaintiff's strongest argument, which is evil motive. And the judge writes a beautiful decision, 20 pages single-spaced, about how Wal-Mart gave reason after reason after reason, and how all of them were false and cover-ups.
Could be found to be.
Could be found to be, but here we had contradictions among the sworn statements, answers to interrogatories signed by the allegedly primary decision maker that were then contradicted by the same decision maker on the stand.
Well, to go back to Justice Spina's question, I guess I'm a little confused too, because we started and you said, the finding of intent to discriminate, which would be a sine qua non of a liability, a compensatory liability verdict, in a gender discrimination case is by itself sufficient to warrant punitive damages, right?
Yes.
So, and you get there because you say an intent to discriminate in such a case equals evil motive?
That's correct. And
So in your view, it is not, to go back to Justice Spina, there is no need for heightened culpability over what you need for
the underlying wrong.
The underlying wrong.
That's correct. And there's 2 cases I'd like to point out. The Smith v. Wade case, which is a Supreme Court case, which adopted the restatement standard in 1983 cases, says where the tort involves wrongful motive, you need not establish anything more than the underlying tort in order to get punitive damages. The courts have said over and over in Handrahan in the First Circuit, numbers of cases saying you need not prove anything more than the underlying discrimination. Now, Justice O'Connor in 1989 said of Title VII that there's no doubt that Congress considered gender discrimination to be an evil in itself. The MCAD has held that discrimination is a, quote, hideous evil that must be extirpated from our soil forever. And this court said in DeRoche that Chapter 151B was established to eradicate the evil of discrimination. How could the jury be wrong in determining gender discrimination to be illegal if the lawmakers are saying the same thing?
But don't we have the problem that the standard of outrageous because of evil motive or reckless indifference comes from the restatement? The restatement is speaking in a context in which there are many states which permit punitive damages in negligence cases. And this standard is really designed for those common law states which have punitive damages in negligence cases, and that says it's got to be more than negligence. It's got to be essentially intentional or reckless. You have a discrimination case where the very nature of the conduct is intentional. Are you essentially asking us to read out the term outrageous and simply say that's surplusage? What really is the standard is intentional or reckless, and since discrimination is by its nature intentional, that is sufficient by itself?
I have a wonderful answer for that. The Smith versus Bell Atlanta case, that's the case that talks about heightened culpability. That's the case that distinguishes outrageous conduct from negligence. We are in no danger of awarding punitive damages based on negligent conduct in Massachusetts. We've established that, and we're not arguing that here. My time is up, Your Honor. Thank you.
Thank you. Mr. Mantell. Mr. Casey?
Thank you, Your Honor. May it please the Court. David Casey on behalf of Wal-Mart, and with me, Stephen Melnick.
I take it, and forgive me, but we're only dealing with the punitive damages piece of this, correct?
No.
No, we're dealing with the whole thing?
Yes.
Oh, we have four separate arguments
I'm-
why
I'm
the
sorry.
judgment should be vacated, and I'd
Okay.
like to turn to those in a moment, Your Honor. But first, if I might just respond to my brother's argument and address the various questions that really concern the collapsing, if you will, of a garden variety finding of discrimination into one that warrants special condemnation
Would
in the
suggest
form
to you
of...
that garden variety is not maybe a term you want to use about intentional discrimination on gender, Mr. Casey.
Fair enough, Your Honor. But what I am saying is this, that the legislature and this court and the U.S. Supreme Court in Kolstad have all made it plain that in...
Holstad's very different. It's looking at a very different statutory language.
It is looking at a different statutory language, but it is also examining the jurisprudence broadly of what supports a punitive damages claim in the context of discrimination cases. And it draws on the restatement, which actually requires intent plus outrageousness, not just merely negligence plus outrageousness, but intent plus outrageousness. And that's what this court did in Dart. And if I might just suggest a practical problem. If a finding of discrimination without more warranted an imposition of punitive damages, then these cases would be fundamentally tried in a different way. Because in the practical day-to-day trial of a discrimination case, there's a threshold question that the judge has to address, and that is, am I going to let in evidence of the net worth, the gross annual revenue, and the financial circumstances of the defendant? And the law is very clear that that information comes in only if there is enough evidence to warrant a punitive damages instruction at the end of the day. And that evidence would otherwise be far more prejudicial than probative in any case other than one in which there was evidence compelling the finding that there was outrageousness and evil motive here. Now, Justice Botsford, I understand your point, and forgive me for the poor choice of phrase. You're right that any kind of discrimination is to be sanctioned, and there's compensatory damages for so doing. And there's emotional distress damages and interest and attorney's fees and injunctive relief and the like. But a discrimination case can be found in a very close context where perhaps it was unconscious. Perhaps it was a close call in a reduction in force or in a hiring decision, and the jury sees it differently than did the manager. But that's a far cry from evidence that shows that over a sustained period of time, a particular manager never hired women, never promoted women, made inappropriate statements about women. They're different kinds of cases.
Do you have any problem with the jury instruction that the judge gave on
I do not.
punitive damages?
I do
So that
not.
was fine.
The standard was fine. The judge said it's intent plus outrageousness. It's more. You have to show a level of culpability beyond intentional discrimination. And the judge should not have given that instruction. Trial counsel objected for defendant to that instruction.
But that's on the sufficiency.
But at the end of the day, the judge decided, after the case had been concluded by the jury, that there wasn't enough evidence to support a finding of outrageousness. Indeed, the judge called it a very close question. And that turns me to my other four arguments.
Let me ask you first. You're now saying that your reason for firing this woman was because she left the pharmacy section unlocked to get a soda. Is that right? And that violated the policy, you say, back in '02 or whenever it was.
There were a couple of aspects to it, but that's essentially right.
Okay. You at one point said that you were firing her because of the failure to oversee the theft of drugs, essentially.
I don't believe that was ever said. The context was this. A new district manager comes on board. He goes to the store to meet with Mrs. Haddad, and he does some pro forma review of some records, and he finds that one of her technicians is maintaining a charge account for drugs that she shouldn't be maintaining. He finds further that Mrs. Haddad had paid one of her personal checks against that inappropriate charge account. He looks further and finds that that technician has forged a prescription with Mrs. Haddad's name on it. He then asks both the technician how that happened. The technician said, I forged it. And he asked Mrs. Haddad, how could this have happened? And she said, it could have happened when I left the pharmacy. And she admitted in that conversation that she left the pharmacy, technicians inside, unattended, and she admitted that she had given them her secret sign-on codes,
Secret meaning
plural.
password, Mr. Casey?
Codes. It was plural. She said and wrote, I gave the technicians my secret sign-on codes, which...
Well, the judge found that she denied giving anything secret at all, including certainly her password, and that anybody working next to her could figure out the code. So is that really fair?
Could have found that could have discerned her sign-on, but not her password. And
she never gave her password to anybody. That's what the judge said.
The judge made that finding. We dispute the basis of that finding.
Don't in your brief.
We do. By virtue of what, and we cite the record on this, Your Honor, what the plaintiff testified to and wrote. She wrote a document, a handwritten document, regarding what she had done that enabled this forgery of a prescription.
I take it, as at least as I read the judge on the closeness of the case, is what the judge was struggling with is whatever you might have thought of Wal-Mart's policies, whether they were fair to employees or not, or whether they treated their employees well or not, what seemed to have been of concern to the judge was it gender-based?
That's exactly right, Your
or
Honor.
as opposed to, the way they treated all of the employees.
That's exactly right, and it points up the problem with the pretext analysis, which this court addressed in the Raytheon-Lipschitz case, and when I think you were exactly right, Justice Pina, in focusing on the need to demonstrate discriminatory animus. Again, this is a case in which...
but isn't a classic way to look at that is you look at what happens to other employees similarly situated. Now, who knows why managers, there may be a policy, and this is just one that they think is over the edge, or this is one that, because it may have been a combination of factors, as you say, the manager looks at it differently. But here, I think the judge is saying the jury had all of that information, right, and they reached a conclusion.
He said it's a very close case, and I just want to emphasize, but not stay unduly with this point, because I have other arguments I'm anxious to make. But I will say this again. The decision maker, Mr. Hogan, there was testimony, uncontradicted, that in 9 chances to hire or promote women to be pharmacy managers, on 8 of those occasions, he hired or promoted women.
That was after the fact, and isn't there evidence that the decision maker was somebody in Ohio or wherever Wal-Mart is located?
There is evidence that Hogan consulted with his boss before he made the decision, and that person participated.
Wasn't there evidence that that person told him, fire her?
There is evidence that one could believe that he instructed him to fire her on the basis of the characterization of the events that Hogan made. But Hogan testified that he was the decision maker, but yes, he reviewed it with his supervisor, and his supervisor gave him the okay.
But one wouldn't have to believe that.
But I don't know what else one would believe. I mean, we have no evidence that Mr. Unruh, the second-level supervisor, harbored any discriminatory animus. There's none. And with respect to Mr. Hogan, what we do know is that he hired 8 out of 9, or promoted 8 out of 9 women to roles of pharmacy manager. And we know that he was there to meet with the plaintiff for the first time and discovered that her technician was maintaining an improper account that the pharmacist was paying for.
Was there any inquiry
He
of
was
Mr.
concerned.
Blackbird about that prescription, the March prescription, the March L4
That
prescription?
Mr. Blackbird didn't admit to leaving the pharmacy. Mr. Blackbird didn't have a technician.
I didn't ask you that. I asked you whether there was an inquiry because it was the same technician. There was, on the face of that prescription, some real questions. Was there any inquiry of Mr. Blackbird, how that could happen while he was there?
No. And there was a question of the technician, did you falsify this under Blackbird's name? She said no.
And
There
you
was-
believe, and that they should just take that even though she's done it a lot before?
I'll address that in a moment, Your Honor. There was also a question of the plaintiff as to whether or not she had any reason to believe that Blackbird was misbehaving, and she said no. And at the end of the day, there is evidence that the investigation here was not as complete or thorough as it might have been in response to your question. That's fair. The decision was made on the basis of what the managers had before them, and the plaintiffs did a nice job of saying that it should have been a longer, more thorough investigation. But that doesn't evidence discriminatory animus. Let me say also that this case was fundamentally flawed. A close case that results in a $2 million verdict. Something.
Well, why couldn't it be considered as evidence of discriminatory animus?
I'm sorry?
Why couldn't it be evidence of it? They're asking all the wrong questions in the course of the investigation. Boy, I'll tell you, ears pop up at that, don't they?
No, I don't think so. There's a pharmacist who is paying off charges that the technician is making improperly. Why is the pharmacist paying off these charges, and why is the technician in violation of policy maintaining a charge account? The flags go up at that point, and then they look at some documents and find that this technician had forged this pharmacist's name. They asked the pharmacist, what have you been doing? And she says, it could have happened while I was away from the pharmacy. And 4.5 months earlier, the company had terminated Mrs. Haddad's male supervisor for doing the same thing.
Oh, he left the building in a car.
He did. He did.
That's different than going to the machine to buy a Coke to come back and eat your lunch at the desk in the pharmacy, isn't it?
Yes, it's different, but in leaving the pharmacy unattended with technicians in there is risk in both cases for falsification of prescriptions, which is exactly what they found to have happened. And I agree, Justice Botsford, this wasn't the best investigation. But I don't think that's the question in a discrimination case. The question is, were similarly situated men treated differently? And they weren't here.
Do you want to get to front pay? And
I do.
mixed motive?
I want to get to mixed motive too, because the fundamental problem with this case is that the judge reversed the burden of proof. He gave a mixed motive instruction in violation of the win-and-win doctrine. Win-and-win says very plainly that you don't give a mixed motive instruction unless and until the plaintiff advances direct evidence of discrimination. There was no direct evidence of discrimination here. The judge gave the instruction anyway and said that in this instance, the defendant bears the burden of proof.
Well, all right, go on. I don't want to interrupt you anymore. Go ahead.
What's your question?
No. You go.
In terms of front pay, but that's an essential point. The burden of proof is reversible per se when you miscast it, when you reverse it. And the mixed motive line of cases, and Chief Justice Marshall, you said this very clearly in Wynn versus Wynn, it's a rare case where a mixed motive instruction is warranted. And Justice Spina, you took this up again in the Raytheon-Lipschitz case where you actually made a point in a footnote and I think asked a very important question. Okay, so we're going to have mixed motive cases and we're going to cast the burden affirmative defense proof on the defendant. What does that do? What does that do to the causation element in discrimination cases? It really complicates it because the plaintiff ultimately bears the burden of proving causation, a separate element, and yet in the mixed motive case, that becomes complicated, if not contradictory. The point is, a mixed motive instruction should be given only in those cases where there's direct evidence of discrimination and no such evidence was given here. Wal-Mart was forced to prove its innocence. That's wrong and reversible. With respect,
I may have missed it. I take it that there was an objection to that instruction.
Yes, there was.
Okay.
And with respect to front pay.
Okay, but before we leave that, the judge did tell the jury that the plaintiff bears the burden as to causation here.
Yes, the judge did do that.
So how does that then go to the harm of the mixed motive instruction if immediately after giving mixed motive, the judge says the burden rests on the plaintiff to prove causation?
I'm making a different point. I'm making a doctrinal point, which is broader perhaps than this particular set of facts. But if the mixed motive paradigm swallows the general rule, then you've got a real problem in discrimination cases with the element of and the burden of on the plaintiff of proving causation. With respect to front pay, 19 years of front pay in a context where the plaintiff did not prove that she would never be able to get full-time work and where she did not prove that she'd never be able to work full-time. In other words, she didn't have some sort of health problem.
How can you do that, though? I mean, she's working part-time for family reasons, and she says, I would go to full-time, right?
Well, no, she didn't say that. What she said is that when a headhunter from CVS approached her and said, you want to come work for us, she said no. She said, I'm not interested in working for a chain again. Well, that's not Wal-Mart's fault. That's not a diminution in pay that is the consequence of Wal-Mart's decision to terminate her.
She did take another job.
I'm sorry?
She did take another job.
She did take another job, but her duty to fully mitigate damages doesn't end with taking another job. She took another job that paid her more per hour, actually, but she can't stay there. She has to demonstrate, if she wants 19 or 20 years of front pay, she has to demonstrate that she's not capable of working full-time or that given her situation, whether it's the market, her profession, physical or mental infirmity or the like, that she could not again work full-time, absent proof of the inability to get back to where she had been in the marketplace, she can't sustain a 19-year front pay award.
I know it's very frustrating when the red light starts to blink, but thank you, Mr. Casey.
Thank you.